Hello and welcome to all of the squirrels of the world. Happy to be back with you guys for another video. First off, I want to say that we did a live stream last night where we watched the Canton Select Board meeting. And I'm glad we did that because, as it turns out, they have taken that meeting down off of their website. It's just disappeared, vanished without a trace. So we did watch the whole meeting, and what we did on the live stream last night was we watched the first half of the meeting, and then we took a break in the middle where we read through the newest affidavit submitted by Alan Jackson, and that's the one with juror number 4, the fourth juror to come forward. And we also took a look at the flow chart that I've made that kind of outlines some of these key issues that were raised in this defendant's motion to dismiss. And then we went back and then we finished the rest of the select board meeting. So if you're interested, you can see the meeting in its entirety in that live stream. Again, it's just sort of split in half. There's like an intermission, if you will. And I will go ahead and include a link for that here in this video, and there will also be one in this video's description as well. We do also have a playlist for the Commonwealth versus Karen Reed. For everything we've covered so far, there's quite a lot of videos there. I think there's over 50 at this point. And then I also have some playlists for other trials and other coverage that I've done. So I'm also keeping an eye out for any new court filings out of Idaho with Chad Daybell and Brian Koberger. Anyway, if you are interested, make sure you check out those posts. Make sure you subscribe so that you, hopefully, fingers crossed, get notifications from YouTube. YouTube's been kind of funny lately, but that's okay. We will carry on. All right, so what I want to do today is I want to talk about some of the key themes in this motion to dismiss, so that when we go to break down and read through this case law, which I plan to do as a live stream, it will make a lot more sense. And actually, honestly, even prior to that point, having some more understanding of these key themes will just help for those of you watching. It will help this motion to dismiss make more sense, because there's a lot of information in this, and there's a lot of information coming out about this case from these jurors and all of that. But understanding this motion to dismiss beyond the fact that, like, you know, we might have a gut feeling like, yeah, it's obvious there was all these problems and things are messed up and like this, but it's a whole different thing to really kind of understand what the defense is arguing, what they have to prove. And even if we speculate that Judge Bev is going to shoot it right down, which she very well may, even if that's the case, it still matters that we can understand it, because it helps us discuss it, and then also it will help us understand the implications of what she decides to do. But what I want to do today is I want to go through two key themes that are really important in understanding the rest of this motion, which are manifest necessity and Massachusetts Criminal Procedure Rule, or Mass Crimp, as it were, 27B. The issues are going to be distilling it down to what are the legal issues, the legal concepts, right? And then the facts are the facts of the case. So the facts are always going to be changing, right? And that's where a lot of what I think is confusing, or can be confusing, because again, there's so many facts and so much information, right, with this case, and we're just having more and more come out every day. But the issues are not really anything new. Now, when you get into how they're going to go through and try to handle those, yes, when you start involving the facts, that's when it gets more complicated. But the root of the issues, it's not all that complicated. So we're going to take a look at that based on this motion to dismiss and the rule itself, the Criminal Procedure Rule 27B, and we're going to take a look at manifest necessity from the case law. So we're going to start out with the manifest necessity. So let's take a look at why it matters here, and then we'll take a look at it in the flow chart. So I'm just going to start right here. This is in the argument section of the motion. This is section B. Re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. Quote, the double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal, and this is from Commonwealth v. Taylor, which we'll take a look at in the next live stream. And then another quote, thus, where a mistrial is entered without the defendant's request or consent. Keywords. Request or consent. Retrial is impermissible okay? Unless there was a manifest necessity for the mistrial. The highlighting thing on Adobe doesn't always cooperate. Sorry. Okay, look at that. It just does what it wants. Okay, so let me read that again. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. I think this is really important for the defense's first main issue, which is this. Now we're going to take a look at the flowchart. So this is the flowchart that I made. So again, there's a lot of different issues and there's a lot of what ifs and, you know, this issue leads to this question and blah, but we have to just start with, in order to really understand this motion and why the case law, why they chose the case law that they did, why it matters, you have to just boil it down into its basic issues again, like I said. So the first one is this question: does lack of objection equal consent to a mistrial? And then again, we will take a look at more of the case law on the next live stream, but that takes you to the case law cited in the document Commonwealth v. Horrigan, which says no, a lack of objection does not equal consent. And then that takes you to this question, which is what we were just looking at. Was the defendant's consent to a mistrial required? To ask ourselves the question, is the consent required? Then in order to answer that, we have to say, well, was there manifest necessity? And once we know the answer to that, then we can better answer this question based on this. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. So basically what this would suggest is that if there was a manifest necessity, okay, and a mistrial is declared without request or consent, then it's permissible to retry it. But there has to be manifest necessity. If there's not manifest necessity, then there's no circumstance where it is permissible. As you can see here, so now I put it in logical order. Was the defendant's consent to a mistrial required? In order to answer that, we have to answer, was there manifest necessity? And we're going to take a look more at manifest necessity. But for right now, what you can understand that to mean is like the example I've been giving is like if a bomb were to go off in trial, okay? Where it's like, there's like an emergency situation type thing. So was there manifest necessity? No. So then we will consult Commonwealth v. Taylor, which says retrial is impermissible. This is coming from Commonwealth v. Taylor. So here, Ms. Reed did not consent to the declaration of a mistrial. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose trial ends without a conviction. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. And they're citing, again, Washington, short for Arizona v. Washington. Before a court declares a mistrial for manifest necessity, 1, counsel must have been given full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. So what they're saying is, okay, judge, there was no manifest necessity established, so therefore, since you declared a mistrial without the defendant's request or consent, a retrial is impermissible. That's what they're saying. But then they're saying, but even still, even if there was manifest necessity, is what they're saying, right? Even if, just in case you decide, which there is no way to argue that there was manifest necessity, but they're just trying to prove, I think, how outlandish it is that this happened the way it did. That no matter what the circumstance, their argument is correct, essentially, is kind of what it looks like. So they're saying, so even if you decide there was manifest necessity, right? Before a court declares a mistrial for manifest necessity, counsel must have been given full opportunity to be heard, and the trial judge must have given careful alternatives to a mistrial. Now, the full opportunity to be heard is what's, like I said, that's where the facts are going to come into dispute, right? How much time was sufficient? In my opinion, as I've said in my other videos, I don't know that it's so much in this case how much time, but when did they have the time? And then how much time did they have when it mattered? Which in my opinion is after they received, or after they finally heard the note from the jury. If you're interested, I timed it with a stopwatch. I'll put a link for that video here on the screen and in this video's description in case you're interested. It's a short video. The rest of this we will talk more in depth about on the next live stream when we go through this case law. So I do want to take a look at something here. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. And that is a quote from Commonwealth v. Horrigan. So that's from the Massachusetts Appellate Court in 1996, and we're going to take a look at that actually right now. So here's Commonwealth v. Horrigan. So again, this is Massachusetts Appellate Court. Okay, so this is the opinion here. In a criminal case, the Commonwealth did not demonstrate the existence of manifest necessity to justify a judge's declaration of a mistrial on the second day of a jury trial when the presiding judge became unavailable, where counsel had not been given an opportunity to be heard, nor had consideration been given to alternatives to a mistrial, nor did the defendant's silence amount to consent to a mistrial, where it was reasonable to believe that an objection would have been futile. Retrial of the case was barred by principles of double jeopardy. So why does this matter, right? Because this is about what happens if you don't demonstrate the existence of manifest necessity, right? Essentially, like we said before from Commonwealth v. Taylor, and as per the flow chart, if you declare a mistrial and you don't get the consent of the defendant, you don't offer alternatives, we know their silence is not enough, right? Unless it's manifest necessity, then double jeopardy attaches, right? And retrying them is impermissible. This is going to be a key. This is going to be key for them, right? And it already is, right? They're relying on this quite a bit in the motion. So let's take a little bit closer of a look here. So this appeal poses a claim of double jeopardy. We reach it after a sequential statement of the case. Okay, this is the part that matters. So as the trial was about to resume the next morning, the first justice of the court entered the courtroom and made an announcement declaring a mistrial as follows. Good morning, ladies and gentlemen. I'm Judge Sherman, and I'm the first justice of this court. Regrettably, about 30 minutes ago, we were informed of a medical emergency in Judge Srago's family, as a consequence of which this case cannot go forth. Wow. I'm required under the rules of the court to declare a mistrial. That means that this case, for these purposes at this point in time, is over, and that the parties will have to start all over again, depending upon what the schedule of the session is. And that, I would assume, you would arrange, please, with the clerk, the jury of 6 office will reschedule this case. I have no idea as to the nature of the emergency, but I've been working with Judge Srago now since the day of her first appointment, and I'll tell you, it's the first day she's ever missed work. I'm sorry for your inconvenience, but you're excused at this point, and if counsel will see the clerk, arrangements will be made for your convenience to reschedule the trial. Before trial commenced on the rescheduled day, the defendant moved for dismissal on double jeopardy grounds. The motion was denied by Judge Srago in chambers. And so that is the initial judge, right? The original judge who had the emergency. Another judge presided at trial. The second trial ended the day it began. The jury found the defendant guilty of driving under the influence and speeding. He was sentenced to 1 year's probation, etc., etc. The defendant appeals from the judgment of conviction, claiming error in the denial of his double jeopardy claim. Yeah. So again, you don't want to have to go through the appellate court, but that's what they did here. And there it is. That's it right there, guys. See, let's all get a better understanding of manifest necessity. Manifest necessity. Where jeopardy has attached, as it did here when the first jury were impaneled and sworn, a judge may not declare a mistrial with a prospect of second jeopardy except for manifest necessity. And that limited power is to be used with greatest caution and for very plain reason. So said Justice Story in the famous passage of U.S. v. Perez, which I believe they also cited in the motion, the defense did. And this is from 1824. The law has invested courts of justice with the authority to discharge a jury from giving any verdict whenever, in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act or the ends of public justice would otherwise be defeated. They are to exercise a sound discretion on the subject, and it is impossible to define all the circumstances which will render it proper to interfere. So what they're saying is, like, again, I keep giving the example of a bomb going off. It's like you couldn't possibly name all of the crazy, random, 1 in a million circumstances that could qualify, right? It's going to have to be on a case-by-case basis. But it's the type of thing where it's like, you know it when you see it, right? But the problem is that then you have other times where the state or the prosecution or the Commonwealth, whatever, might try to argue its manifest necessity to get around violating somebody's rights, which is why it's such a big issue here, because I mean, the Commonwealth, I think they would be crazy to do it, but they were crazy already. So, but should they try to argue there was manifest necessity, like a deadlock jury is not manifest necessity. So that's the thing, right? But should they try to argue it's manifest necessity, then they're going to have to look at it and be like, yeah, no, it's not, right? To be sure, the power ought to be used with the greatest caution under urgent circumstances and for very plain and obvious causes. In light of the importance to the defendant of the right to be free of exposure to a second jeopardy, the burden of justifying a mistrial purporting to rest on manifest necessity falls on the Commonwealth. And then see Arizona v. Washington. An appellate court shall be deferential to the trial judge's exercise of discretion in ruling that a manifest necessity exists for a mistrial only if it is clear from the record that the judge has given careful consideration to the available alternatives and to the defendant's interest in having the trial concluded in a single proceeding, which means not in a mistrial or a retrial, right? In Stewart, Commonwealth v. Stewart, the court said two principles emerge for guidance. One, counsel must be given full opportunity to be heard, and this is cited as well in the defense's motion. We just talked about this. And again, we will read this case law in depth at the next live stream. Counsel must be given full opportunity to be heard, and two, the trial judge must give careful consideration to alternatives of a mistrial, to a mistrial. So in this present case, neither of the principles was observed. The statement of the first justice was sudden, brief, and unexpected, and this is exactly what's cited here in the motion. Neither preceded nor accompanied by discussion with counsel. There was no consideration of alternatives. Right, this is exactly what they said. So the Commonwealth argues that even if manifest necessity did not exist, the defendant's constitutional claim should fail because his counsel consented to the mistrial by not registering an objection at the time. Again, this is all super fucking relevant, right? The Commonwealth points to the moments during which the first justice spoke, more particularly perhaps the interval between the speaker's third paragraph and the end of his statement, at which time the defendant could have considered and then uttered an objection. This underestimates or ignores the difficulty of reaching a decision in which the defendant has an evident personal stake. Whether the defense would be advantaged or the opposite by a second trial, the possibilities ahead, such as the appearance of a new prosecution witness, and cannot instantly be calculated. You guys, this is really good case law for the defense. Therefore, to equate silence with consent when the occasion comes abruptly and unexpectedly seems quite unwise. And you know what? We even heard the same languaging from the jurors, which we don't know if it's because they maybe at that point, like especially the one that just came out yesterday, juror number 4, we don't know if maybe they had read the motion or heard some news reporting on the motion and heard Jackson's languaging. But, I mean, they said they would be willing to come in and testify, right? If need be. And we all saw it. It was quick. It was really quick, and it felt really abrupt, and it felt weird. It felt weird. So I don't think it's out of the realm of possibility that it felt even weirder to the jury, right? But it's just interesting because even what we hear from the juror, that juror that spoke out yesterday, supports the defense's argument here. Right, when the occasion comes abruptly and unexpectedly seems quite unwise. And an examination of the decisions shows that where silence in the face of a declaration of mistrial has been held to indicate consent, the total situation was such that the defendant could have reasonably anticipated that the issue of a mistrial would arise and could prepare himself for the event. So here, they're recognizing the case law that would say the opposite. This is what I was just saying. I wonder what they're going to do. What this is saying is, like, when the silence was enough to have indicated consent, those were situations where it could have been reasonably anticipated that the issue of a mistrial would arise, and then the defendant could prepare themselves. So that is tricky, right? Because that's where the very specific arguments are going to come in regarding the facts of this particular case and the timing of it. And this is where we're going to get into Rule 27B, and I'm going to show you guys why I think this matters. Because I think that there's actually a really good argument here for the defense, more than just beyond what's obvious. So again, in this situation, they're saying that the defendant could have prepared himself for the event and that silence could have been plausibly read as acquiescence. Okay, so remember, guys, what we had talked about before the mistrial was like officially declared and what we thought was going to happen. We had already read Rule 27B, which we're going to take a look at right now. So we were expecting what we had read. We were expecting after that Tui Rodriguez instruction, we were expecting if they still come back hung, we were expecting Judge Bev to follow what is outlined here in this rule. Again, this is from the Massachusetts Rules of Criminal Procedure. This is Rule 27B. So that didn't happen. And it's interesting because the jury doesn't know this rule. However, it seems like, at least from the juror we heard from yesterday, they expected her to ask more follow-up questions, and they didn't expect it to just be over. They were like sideswiped again, right? Judge Bev, I've been joking this whole time that, to quote Trooper Paul, that Judge Bev has sideswiped not just the defense but the Commonwealth, but she sideswiped the jury. And they didn't even know the rule, which is crazy, right? Like that to them it was so intuitive that she should ask more questions. But if you look at the rule, she's required to. So here's the thing. While it doesn't mean that, unfortunately, that Judge Bev can be getting in trouble or whatever, judges make mistakes, that's not where this is relevant. But where this could be relevant is for the defense to make the argument, right, based on this case law here, for the defense to make the argument that right here, in terms of the anticipation of a mistrial or not, that given the quickness of everything, given the speed, given the fact that they didn't get to read the note and they heard it at the same time we did, and then given the rule that a mistrial could not have been expected because, at the very least, she should have followed the rule. So in other words, this I think gives them the argument of what they would have expected, what they should have expected, and I would imagine did, is for what is outlined here in the rule for Judge Bev to follow that. Okay, so let's talk about what this says. So where it says offenses or defendants, just ignore defendants isn't applicable here. It's offenses, right? So for Karen Reed, she had 3 separate charges, okay? Each charge is an offense. You can use those synonymously. So 3 separate charges, 3 separate offenses, okay? Count 1, count 2, count 3. It says that the jury may, with the consent of the judge, at any time during its deliberations, return or be required by the judge to return a verdict or verdicts with respect to the defendants or charges to which a verdict has been reached. And thereafter, the jury may, in the discretion of the judge, resume deliberation. Let me talk about what this means, because the languaging matters. What this is saying is, like, if the jury's deliberating and they have a verdict on one of the charges, let's say there's 3 charges and they have a verdict on one of them, but they're still working on the other 2, they can come up to the judge and say, hey, we have a verdict on one, right? And if the judge consents, the judge can say, okay, great, excellent. Now go back and continue working on the other 2. And that first verdict will still stand regardless of anything else. Even if they come back hung on the other 2, the first verdict will still stand, okay? Because the jury can resume deliberation. The judge, this is the next part, the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict. This is the important part. Provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. Now, here's the thing. It uses the word may here. It says, provided, however, that the judge may first require. It does elaborate further down, so let's take a look. This is subdivision B because it's related to the B subsection we just read. Okay. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. So here's the thing. This languaging is different than what's above. This says it must receive. So again, well, it seems like, should that mean that Judge Bev faces repercussions for not following the rule? Of course it seems like that, but that's probably not going to happen. But where this is more relevant, in my opinion, is the fact that the defense can then use this to say, well, we did not expect her to declare a mistrial because we expected her to follow the rule, in which case she would first ask them which verdicts they can agree upon for each of the counts, right? Separately, to ask them more questions. Are there any you can agree upon? In which case, sounds like, from everything we know so far, they would have said yes. Hopefully that makes sense. I do believe that manifest necessity is referenced as well on here. Yep. It is within the discretion of the court to declare a mistrial where there is manifest necessity. Unless such manifest necessity exists, a second prosecution will be barred by the double jeopardy clause. And to the end that people sort of say, well, the jury didn't ask. Here's what I have to say about this, is that it shouldn't be on the jury to ask. Especially when they may have been intimidated by Judge Bev. We don't know. But regardless, it is not their job. It doesn't make any sense to me, for justice, just to have jury instructions or verdict forms for that matter that put any responsibility on the jury to think of things that should have been addressed in the jury instructions or should have been addressed in the verdict form. And I understand, the thoughts of like they could have raised, the defense, for example, could have mentioned some of these things during closing arguments. But the thing is like, this is really an extenuating circumstance. Like, you don't want to maybe suggest to a jury that they shouldn't come back not guilty on all of them, first of all. But second of all, what do they know from Judge Bev? Well, they know that what the lawyers say is not evidence, okay? And what did she tell them time and time again? If you're confused, if there's any discrepancy, they have to go with, she says go with what I say, but if they're back in that jury room, they're going to be going off of the jury instructions, which we heard her read. So they're going to go off of the jury instructions. So even if the defense had said like, yeah, just in case, if you guys can't agree on one charge, but you've got a verdict on the others, you can always render a split verdict. Like, if they heard that, but then they're in the jury room and they're like, God, what was he saying about that weird split verdict thing? And they look at the jury instructions. The jury instructions are clear. The jury instructions are very clear that they are not supposed to fill those forms out until they have a verdict on each charge. It's extremely clear. So the problem, in my opinion, is with the jury instructions. Now, again, this is where all the facts matter. The defense could have objected, right, to the jury instructions. But for that, I want to remind everybody of something really important, which is this. They do not leave that end of that day finishing everything. They finish the end of that day with issues that are still on the table. And not just the attorneys, but even the court staff has questions and issues. And the way she cuts everybody off at the end, she says several times, yep, we have time to discuss this. We'll finish it tomorrow. And I know for those of you who've heard this before, I apologize because I was so surprised because as I finished that live stream, I even said, oh, that means they're going to come in the next morning and before closing arguments, they're going to finish jury instructions. And that's what I was expecting. So we were watching it live and she marches in and she's like, all right, closing arguments. And I was like, wait, what? Her own words were, yep, we'll finish this tomorrow. She's trying to get off the bench. And so there were still issues that needed to be ruled on. There were still things that needed to be talked about. Again, not just from the attorneys, but even from her own court staff. And rather than make sure that everybody's on the same page, rather than make sure that all the loose ends are tied up, all the T's are in the I's, all, whatever it is, cross your T's and dot your I's, instead of making sure that everything's done and everything is correct and not even showing the verdict forms to the defense. So that's the other thing. She didn't show them the verdict forms. And in fact, it looks like she didn't even bother to read them because once they finally started arguing over that second charge, remember how many other errors she found? She found error after error. This needs to be indented. This isn't the right format, blah. And it's like, did you not even read them? But the defense didn't read them. We know that for a fact. The other thing is because she hadn't, this is the argument, this is where I would push back saying that they could have done more because she didn't finish ruling on the jury instructions. They did not finish talking about the jury instructions. She just made those decisions, which means she must have left them as is. But what it doesn't mean is this. Like normally what would happen, and we see this in other trials, when they're discussing the jury instructions and they're talking about doing this or that, blah, blah, they're making changes. They finish talking about it. And then a finalized, like a draft is provided to both parties to look over. It's like the updated version with the changes, and they look over it again, and they'll make more changes. If you guys, for anyone who watched the Kowalski versus J. Hatch trial, they had already started on the jury instructions before the trial started, and every single day of that trial, they took time to update those jury instructions. It's a great example of that process where literally multiple times a day, every day of that trial, they had times where they literally just brought in their appellate attorneys, and they went through and they talked about the jury instructions and they made changes to it on like a daily basis. And there were several drafts that were provided throughout the trial, and then they would still update them. And then they really took a lot of time before approving that final version. All of that was, it's crazy that was all skipped. So there were still issues up in the air. They hadn't decided about several different things. So to think that the defense in other words, my point is the defense could not have even seen a final draft. It's like she sideswiped them with the jury instructions and the verdict forms. Again, think about the verdict forms, right? Another great example. They never saw them and they were messed up. So I think that just like with the mistrial, my thought is that the defense here probably it was a lot of the same, where they thought, oh yeah, well, Judge Bev told us we were going to finish talking about the jury instructions. She said that. She said, we'll have time tomorrow. Again, me as a viewer, you can go back and look in real time. It was like, yeah, obviously they're going to finish the jury instructions tomorrow before closing arguments, and then they never did. And I'm sure that's when they were also expecting to see the verdict forms, but she just skipped all of it. And then it was the same thing with the mistrial. Like here again with this, the idea that they could say, well, they were expecting her to follow the rule and then to ask further questions of the jury before declaring a mistrial, and that's why it's unreasonable to say that they should have been expecting it. But what does she do? She sideswipes everybody, including the jury. So hopefully this sheds some light on this for you guys. That's it for now. I will be keeping an eye out in case there's another juror that comes out and speaks. It's entirely possible there will be something else happening. And again, for anyone who missed it, you can check out that live stream from last night where we watched the Canton Select Board meeting and also read the latest affidavit with juror number 4. But other than that, that's it for now. So as always, thanks for being here. Thanks for being a squirrel, and I'll see you on the next video.